District. Hi, good evening. I'm Liz Krueger, State Senator for the 28th District. I'm glad to see all of you who are here with us tonight, and I'm not seeing that many of you, but I'm reminding everybody that if you're on Facebook and watching us that way, you can type in questions, which we will follow up with as many as we can. We have quite a few questions from before the evening even started. And if you were with us by telephone, unfortunately, you don't have an opportunity to share questions anymore. And you also must keep your phone on mute. This is not a live back and forth conversation with people who are watching tonight. I am delighted to remind everyone that they will be able to watch this at a future date on Facebook. If they wish, it stays up. And we've seen that hundreds of people watch after we have already finished these shows. I know that people are finding this information incredibly valuable as we do these events every week because we get so many follow-up calls from people looking for more information. I never do anything lately without reminding people, if you go outside, wear a mask, keep at least 6 feet apart from each other and from anyone you bump into anywhere, and wash your hands so often that you think they're going to fall off. They won't fall off, and you can choose a different song to sing to make sure you're washing your hands and scrubbing for a good 20 seconds. Some of us are busy with protests or avoiding protests in the streets right now. Again, re-emphasize, need to stay 6 feet apart, need to wear your mask, and try to avoid pepper spray because it actually ends up causing all kinds of coughing, which is definitely what none of us want to be doing. Before we get into the topic of tonight, I want to briefly touch on a couple of other critical subjects. My office has received literally thousands of emails and texts and calls regarding the current national and local response to the murder of George Floyd. I join my colleagues, movement leaders, and activists in urging continued nonviolence by protesters. Peaceful protest is everyone's right and is in fact a fundamental model for our country's success. The vast majority of people who have taken to the streets to protest are in fact doing it correctly. But we must not lose sight of why these protests are taking place, and we must take action to address the underlying causes of the situation. Let's see. As a start, I am proud to be a co-sponsor of legislation to repeal what we call the 58 law, which keeps police disciplinary and complete records hidden from public review, along with a host of other much-needed reforms. I and my colleagues in the Senate and the Assembly are working to pass this bill and others, which we think will significantly improve community and police relationships because it will provide for transparency and honesty about what's happening with, I'd say, a small number of police who don't seemingly know how to do their jobs correctly. These are historically challenging times. We're dealing with a pandemic, a radically high unemployment rate, income inequality, and the ever-present pernicious racism in our society. It will not be easy. There will be pain and stress, but we must hold hands and stick together. We must learn from each other. We must listen and respect all the different voices and reach a better normal. I know we can. Some people are young and they think this country's never gone through bad times before. That's not true. We can get past this also, but we have to be thoughtful and present and all commit ourselves to getting to where we need to go. And so now it seems somewhat appropriate that our conversation tonight has to do with cooperative, multi-household living in our city. Tonight's event is the second part of a series on housing to address the concerns and questions facing shareholders, condo owners, small homeowners, particularly during this pandemic. I'm very happy to be joined by my guests for the evening, two experts in the field of cooperative condo ownership, Kevin McConnell of the law firm Himmelstein, McConnell, and assorted other names, and Rosemarie Cantanno, Associate Director of the New York Legal Assistance Group. First, I'm going to allow Kevin to present, and then we'll get back to Rosemarie, and then we'll have an opportunity where I'll get to ask them questions, and they will see how many we can possibly get through in a 1 hour time. So, Kevin, I'm going to let you start us off.
Thank you very much for inviting me, Senator Krueger. I appreciate it. There had been an old Broadway show, Camelot, and one of the songs in Camelot was, it's May, the lusty month of May. And for New Yorkers, May generally entails the lusty shareholders meetings. But in these times, not too many co-ops have actually had these meetings because of the restrictions on the number of participants in any meeting. However, New York State law, specifically Business Corporation Law, Section 602, provides that shareholders meetings can be done virtually. They can be done by some platform, be it Zoom or Meet or whatever, as long as there are reasonable steps taken to, one, allow people to participate in the meeting, two, to make sure that the people who are present at the meeting are indeed shareholders, three, to allow that there be voting. Voting can be done electronically or by proxy, and four, to make sure that there is a record kept of the meeting, either by recording or by some sort of minute taking. So it is completely within the discretion of the co-op board as to whether to have such a virtual meeting, but it is indeed possible, and it is a way for the shareholders to meet and have their election for a new board and deal with whatever business might come up otherwise. Additionally, even if it's a condominium, courts have held that the governance of condominiums are generally run in the same manner as co-ops, so condominiums can also have virtual meetings of their unit owners. So even though you may have passed, you might not have had the opportunity to have a meeting, because I know many of the meetings have been put off to the fall. It's still indeed possible, and it can still be done over the next few months. Thank you, Liz.
Thank you, Kevin. All right. So next, I'm going to turn it over to Rosemarie Cantanno to give us an opening presentation. Hi, Rosemarie.
Hello. Good evening, everyone. Thank you so much for the opportunity to speak to everyone. I work for the New York Legal Assistance Group, which is a not-for-profit legal services agency, and we have been trying very hard to get the word out to homeowners and co-op owners about what is happening right now. We know that with everything going on, with this pandemic, with people losing their jobs, and now with the new situations, it is kind of hard sometimes to focus on your bills and to focus on the mortgage. And, you know, we all see a lot of headlines and we all see a lot of things will come out in the paper, and you'll see no need to pay a mortgage for 6 months, no need to pay your rent for 6 months. So one of the first things that we're really trying to get out to people is, if you are in the financial position where you can't, sorry. If you are in the financial position where you can pay your maintenance, you can pay your mortgage, please do so. It is not going to be a matter where people are going to, the banks are going to automatically say, okay, your last 6 months of mortgage payments are no longer ever going to be due. Even in the best scenario, most likely they're going to be put on the end of the loan. They're going to be put back into payment plans. You know, I know that anything can happen, and I believe that now more than ever, but I would definitely not bet that someone was going to give, quote, a free ride or whatnot. There are all different types of loans, and it is very frustrating. If you have a mortgage on your home or a loan on your co-op, people all the time want me to say, well, what is going to happen? Problem is, depending on what kind of mortgage you have, it can be completely different. FHA, the federal mortgages, they've come out with some more direct guidance. if you have what's called a mortgage by Fannie Mae or Freddie Mac, they're supposed to put the arrears on the back in a balloon so that you won't have to worry about it 6 months in. But there is no guarantee. Unfortunately, things are changing every month. The most important thing is to reach out to your servicer, reach out to your bank, or reach out to an organization like mine where we can look up your specific mortgage, talk to your bank, and figure out what your real choices are. Thank you.
Thank you. So again, before we start the Q&A, just I'm reminding, if you're calling in, please keep your phone on mute. This is not an interactive show where you can get online and ask the question directly, but questions are pouring in from the Facebook, and I had many questions that people who signed up for already sent us in advance. Just to clarify, we're not going to get into too personal a question. So if your question was more general, it's more likely to be asked here tonight. If your question's not addressed during this show and you live in my district, please feel free to call or email my office and we'll follow up with you. My office will also be sending an email to everyone who RSVP'd for tonight's event with advocacy information. And in the coming days, this information will be posted onto my website along with the video of this event. So there'll be ways to follow up on Facebook, through my websites, or just one-on-one reaching out to my district office if you live in my district. And if not, I urge you to do the same with your own senator or assembly member or council member. I think we are all very attuned to these issues at this time. All right, to start with the questions that we got in advance. So, COVID-related questions starting. How should co-ops manage to handle the anger and emotional anxieties expressed by residents towards each other and the doormen concerning wearing COVID-19 masks, lost packages, because we get everything by mail now, or delivery, managing social distancing in community spaces, and then paying fees for gyms or amenities that aren't available during the COVID-19 quarantine? Are there any specific legal tips you could offer, or just what you think of as smart common sense towards your neighbors tips you could offer?
I think it's incumbent upon unit owners, shareholders to act reasonably, to understand that the board that they have elected to represent them and to make decisions on behalf of the corporation, those decisions have to be respected, that they are in a tough bind as well. Most co-op board members are just neighbors, folks who live in the building. They too are impacted by COVID. They're impacted by the failure of a neighbor to wear a mask, failure of people to social distance. So I think it's incumbent upon people to act reasonably, to appreciate the crisis and the stress that everybody is under, doormen, superintendents, porters, and to act reasonably. Best advice that I can give. Not legal. I'm a lawyer, not a psychiatrist, but I think that's helpful.
Rosemary, anything else to add there?
No, nothing specific. I mean, unfortunately, when bylaws and whatnot were put together and house rules, a pandemic never was something that was thought about. So really, just like in every other parts of our life, we're really, just trying to work through this in a way that is the most respectful to everyone in the building, since we have many buildings where you may have children and you have senior citizens, right? And maybe you think it's fine for you to be downstairs talking to the doorman without a mask on, and in reality, you're putting everyone in the building at risk.
Exactly. When I try to explain to people about any issues going on right now, one, even if you're not someone who imagined ever thinking through mental health concerns for yourself, or even trying some of the relaxation techniques that people who meditate every day may have mastered, this is probably the right time in your life to think about doing those things. There is so much free-floating anxiety and stress in all of our lives that figuring out ways to get that tension out is a good thing for you and anyone that you interact with, including particularly the people who might be sharing a home with you. The second rule I try to follow is recognizing that at this point in history, everyone is screwing up. We don't have all the answers. Because again, we haven't lived through a pandemic before, and I'm not sure this one is like any other one anyway. So government doesn't have all the answers. Healthcare providers don't have all of the answers. There's a lot of trial and error trying to get us past this, trying to keep us healthy. So I try to remind myself and others, the blame game doesn't work very effectively. Even if you're really mad about something that happened or happened wrong, in your opinion, try to give the benefit of the doubt that people are trying to do the right thing. They're trying to get you the right answers. And frankly, a lot of the time at this moment, we don't have those answers. So practice forgiveness is my philosophy at the moment, even if you might be thinking other things. All right, in my building or co-op, is my building or co-op board required by New York City and or New York State to inform all residents about the presence of individual residents or building employees who have tested positive for COVID-19 or have self-quarantined because of COVID? Are there any rules about that and telling people things?
I mean, what a co-op board has to be mindful, of course, is privacy and medical privacy and whether they can disclose a particular shareholder's condition. That is a tension. They have the stress is to the individual shareholder's privacy, but I understand that people want to know, has my neighbor shown any symptoms? Has my neighbor tested positively? But I think the overriding concern for a board member is they may know that the COVID exists, but they have to be very, very extremely careful as to whether they identify the person who has the symptoms or the disease.
I agree on the privacy issues. This is it came up on the Facebook, and it's the last part of the previous question again. Can they make you pay fees for gyms and amenities when they're not open? Don't you have the right to that money back?
Oh gosh, there again the tension, the stress. The stress is that the co-op board is probably encountering people who are having difficulty making their monthly payments in any event, the monthly maintenance payments. For those who can afford it, as Rosemary urged, they should pay. Another source of income, of course, is the use of the facilities. And in a co-op, it's a tough question. I'm not able to use the gym, therefore, why should I pay the gym fees? Entirely reasonable, but again, it's not like a private landlord situation where there is a landlord who is making a profit off of this. This is a co-op. The fees are supposed to be set at the rate to pay the co-op's bills, to pay for the porter, to pay for the super, and without that kind of cash, there's a possibility that other services will be cut back, which will be even worse. So I would urge people to, consider that in making the determination as to whether they pay their gym fees or not.
Fair enough. Thank you. Is a co-op board of directors allowed to refuse a meeting, virtual, with shareholders and still demand an assessment because of the loss of commercial tenants' rents during the COVID shutdown? What compromises can a co-op board make to lower these huge assessments being dumped on the shareholders?
Well, as I said earlier, the business corporation law that allows for virtual shareholders meetings is optional, not a requirement. So the board can, in its business judgment, and that's the standard by which co-op boards are held to, can determine that it's more appropriate to have the meeting at some time in the future. With regard to the loss of commercial rents, there are other possible alternatives, and perhaps Rosemary can speak to one of them, and that is, does the building have a line of credit? A lot of buildings have underlying mortgages and also have lines of credit that they can draw upon. There has been also some discussion among the co-op bar that perhaps the co-op can look into its reserve fund to cover the shortfall and therefore impose the assessment, but impose them over a gradual period of time, reserve fund, if the reserve fund is used for operating, which is not the best practice. However, it might be one of the only alternatives. And of course, any combination of all of that.
I mean, so much is dependent on the financial health of the particular building. There are some buildings that will have enough reserve to, hold out for a few months and maybe not. But there are buildings that what they bring in is pretty much what they spend. And then, of course, it's much more difficult because you still have to pay the doorman and you still have to put on the air conditioning. So it really comes down to trying to figure out the best way to keep afloat until residents get back on their feet.
And a question that just came in, I think, on this topic. If I'm a rent-controlled renter living in a condominium building and an assessment is applied, say a COVID assessment because some people aren't able to make their payments so the building needs more money, can that assessment for owners be applied to rent-controlled units as well?
No, that's a definitive answer, no on that one.
Okay, good. So renters in these buildings do not get hit with these assessments.
That's correct. They're protected either under the rent control laws or the rent stabilization law.
Right. So there's nothing unique about calling it a COVID assessment that gets you around us as a board.
No, not
Somebody will be very happy to hear that. Thank you. Do tenants have the right not to vacate during normal circumstances or during COVID-19?
Not quite sure if I understand the question. By tenants, is it, well, let me answer. Let me make up the question, then I can answer it.
Okay, fine. I'm not sure I can help you better than what I read.
Okay, fair enough. Can a board impose restrictions upon who comes into the building to help you move? Restrictions as to whether people can move and whether the building wants strangers into the building without any sort of protection or any kind of restrictions. Again, my best guess is that the board probably can do that. Probably can restrict as to who comes into the building and under what circumstances they can come into the building.
Is there any mechanism to forgive maintenance fees during this time because of COVID? I guess, hi, I lost my job. I'm really hoping you'll forgive me these months and I won't owe them to you. Is there a model for that?
I mean, I know that the co-op I live in, the board got together to figure out a policy. Did they have a policy for something of this nature? No, because it's, there in most co-ops and condos, there may come a time when someone can't pay for a month or two, right? And that's a small, short thing, or it's one unit out of 100. But I think boards can agree, and co-ops and condos can agree to forgive things or do different kinds of plans, but obviously they have to follow the rules of the co-op in passing that.
I would agree, yes, Rosemary.
Thank you. Well, I don't know why you would know this, but here we go. Are co-ops qualified to apply for the federal PPP program, which was that small business loan program the Fed set up where if you showed that you weren't going to lay off people during this time and were going to use the loan funds from the federal government to keep your employees whole, that then this might move from being a loan to not having to be paid back. And they were relatively short term, like about 4 months maximum. I don't know whether a co-op would be defined as a small business for this purpose.
So again, not answering as a lawyer because I haven't looked into it, but as someone who lives in a co-op, our co-op attorney, and I live in New Jersey, did tell us that we would be able to apply possibly for things like the doormen, the maintenance men, for the salaries that are attached. Now, this is just what I was told by our person, but it's possible. I mean, I think that if you're a co-op or a condo board, you should be looking into everything. I mean, at this point, I think nobody should just say no. Ask the questions.
Right.
And I'm a member of the New York City Bar Association called Condo Committee. And I would say the lawyers on the committee are pretty much evenly split as to whether co-op and condos can qualify and should apply nonetheless. I know Senator Schumer has taken an interest in this and has had some discussions with some members of the Bar Association committee and talking about making it clear in the legislation that co-ops and condos do indeed have the right to apply for the PPP. But I say definitively.
So I do think it's important to remember that there's no guarantee it's going to be a forgiven grant. It could possibly stay a loan. So when you're figuring this out, figure it out as if you have to pay it back.
Correct. It's also true that we moved through the funds pretty quickly. There was a first round, and those disappeared very quickly, disturbingly by larger companies, not small companies. And then there was a second round where they tightened up the eligibility so that larger corporations and franchise build companies couldn't apply. I believe there is still some money available through that round too. So I also take the philosophy, if you think there's something out there that might be helpful in your circumstances, give it a try. What's the worst that happens? You get told no. But I don't know the specifics. And there may be different rules depending on lots of different things. Is there any recourse for a co-op from the non-payment of commercial lease tenants during COVID-19? So the restaurant closed, so they're not paying their rent. Pretty much any kind of store that might be on the first floor of your residential building very likely was forced to close for some period of time. So when they don't pay you your rent, what can you do as the co-op board, the condo board?
The only remedies that I see is that you would have to sue for a non-payment of rent. As it presently stands, the courts are not wide open to that, although I have heard that the New York State Supreme Court, however, is open, and some landlords have used that rather than going into civil court, landlord-tenant court, going into Supreme Court, seeking judgments for the rent and judgments of possession. But that's probably the only recourse. I would never tell a co-op landlord, which is what a co-op is in those circumstances, to engage in self-help, to lock out the restaurateur, to lock out the clothing store owner. You always go to court, yes.
Okay. And again, the other side of the last question, those small businesses should try to apply for the PPP and other program funds because they might actually get additional money that will help them reopen or pay the bills they couldn't pay at the time where they didn't have any revenue coming in. So even if your building learns they aren't eligible or they're not going to try for PPP, they might suggest to their commercial tenants, hurry up and apply, because there's a city program, a state program, and a federal program now to support loans and grants to small businesses to help them. So I would encourage everyone to recommend that to anybody who's a commercial tenant. Okay. How would I conduct a virtual over-the-phone shareholder meeting and voting for board officer positions?
Yeah, as I said earlier, Section 602 of the New York State Business Corporation Law allows for virtual meetings as long as certain safeguards are met. Making sure that the participants are actual shareholders, having them register either at the meeting or prior to the meeting. Try to do as much as you possibly can by proxy, and have proxies which are directed proxies, that if there are issues that you know are going to be raised at the annual meeting, have the person who is the shareholder who's given the proxy direct their proxy holder to vote a certain way. Have a platform by which the shareholders can participate in the meeting, and try to run it as much as possible as you would if you were gathering in any one place. So it's a possibility, not an obligation, but it's a possibility, and New York State law does allow for that option.
excuse me. How should supervision of contractors or repair personnel take place at this time? What if no one is willing to do that?
Fire them. No, I mean if it's plainly if it's a contractor that's employed by the co-op or by the condominium to do work and they are refusing to take precautionary measures such as masks, distancing as much as possible, the co-op or condo has the right to terminate that contractor. If it is a contractor who's been brought in from the outside to deal with somebody's renovations in their own individual apartments, again, the board, that person probably entered into an alteration agreement with the co-op, and that alteration agreement likely provides that the contractor and the shareholder, even more importantly, the shareholder, will abide by the condominium or co-op rules. And failure to do so could result in a shutdown order. Bar the door. Don't let that contractor in anymore if they're not willing to take these sort of precautionary measures. You don't want to put your other neighbors at risk. You know, these people are your neighbors.
So we got a variation on this question a week ago when we were dealing with renters issues and the concern of, say, elderly and medically vulnerable people who are being very, very, very careful about quarantining, not wanting to let landlords or repairmen into the apartments because of the fear of COVID, and just trying to clarify, if it's an emergency situation, you may have no choice but to allow your landlord and whoever's repairing something to come in and repair. But if it's not an emergency, the answer there was, then you don't have to let them in. Would that sort of be the same rule of thumb in a co-op condo situation?
Yes, in a co-op situation, the shareholder and the corporation are both bound by the proprietary lease, which is not at all similar to what a renter has with their stabilized and unstabilized apartment. And the proprietary lease generally provides that the shareholder must give reasonable access. Is it reasonable to come in to fix a hole in the wall under these circumstances, particularly if the shareholder tenant is in the vulnerable population? I would say it's not reasonable. What would be the co-op's remedy? Well, they would have to send them a notice that you're in default of your lease. If you don't cure the default, you could be terminated. So then you still refuse. The co-op sends out a notice of termination. You still refuse. Doesn't mean you have to move out. The co-op would have to go to court to enforce that and to seek a judgment of possession. And even at that time, there's a provision in the New York state law which allows a tenant shareholder to cure that default, even if the access refusal has been held to be unreasonable. So the shareholder has a lot of remedies, a lot of ways in which to refuse and to not allow, particularly under these circumstances.
So this is an interesting, timely question for me. What about Local Law 152 with gas line inspections? And is the city going to actually fine buildings $10,000 if they can't comply with this at this time? You heard anything about that?
Sorry, nothing. I can't add anything to that. I just think that the administration would be extremely unreasonable if they start hitting co-ops with these sort of fines under these circumstances.
I said it's very personal for me because today Con Ed did an inspection, told us that the line running into our co-op from the street was corroded, and they shut down our gas and said it could be weeks or months before we come back here. It's their responsibility. It's in the street, but they said don't hold your breath for when we get around to fixing anything. So that's why I didn't write this question, but now I'm like, my life will now be all around we don't have gas or hot water. So I'll be practicing cold water showers and seeing if I survive those. All right, a little too personal, TMI, as the teenagers say. Let's go to board of directors. Who has given up Who has given co-op boards such tremendous power over shareholders? Don't shareholders have any rights?
Well, you voted them in. If you don't like the decisions that they've made, the policies that they've followed, you can vote them out.
Mm-hmm.
Unfortunately, that's basically what the courts have held. If there are extreme actions taken by co-op board members that you can show they're stealing money, for instance, then you can commence an action in New York State Supreme Court to have that person thrown off the board. But in most cases, co-op board members don't take such actions. Therefore, you wait for the next shareholders meeting. Co-op owners generally in the bylaws have the right to call a special meeting for the removal of directors if they gather 25% of the shares in a petition to the board, and the board has to hold the meeting. And in that circumstance, you can throw the rascals out and put in new board members. We've done it. We've done it on several occasions, Senator. We've helped organize shareholders. They've made the petition. We've had the meetings. In one instance, it was a virtual meeting, and we had enough votes that the board members that were negligent, uncommunicative, were thrown out of their positions.
Can boards stop shareholders from showing up at the meetings? Can they refuse you entrance to a board meeting?
To a board meeting? To a board meeting, probably can, yes. That depends upon the policy of the board. Most boards do not open their meetings to the shareholders, and that's not really any kind of a violation of law.
Okay.
I think on the board meetings that, maybe you don't want to have public, not necessarily because people are hiding them, but because they're items discussed.
And if your bylaws say that there should be advance notice prior to doing an assessment, and yet they don't, and they keep doing this year after year, is there any way you can push back on that as a shareholder beyond turning over the board?
Well, if I talked a little bit about the business judgment rule and the court's deference to the judgments and decisions made by the board. But some of the criteria are that the board has to act in accordance with its own procedures. And if a board doesn't act in accordance with its own procedures, then the business judgment law is not a defense. In effect, what the co-op board has done has breached its obligations to the tenant shareholders if they don't follow their own rules. The remedy of the tenant shareholder, withhold payment of the special assessment, which could lead to the drastic notion of being sued for non-payment of rent, or they can pay it and bring an affirmative lawsuit, small claims court or civil court, to recover those monies that they have paid because the board imposed them improperly.
All right, we're going to move on to mortgages, which I think actually that Rosemary, we often turn to Rosemary for mortgage questions in my office. How can mortgage companies expect us to pay one lump sum at the end of the forbearance period? If we don't have the money now to pay our mortgage, how can they expect the money in one lump sum at some future date?
It's a major problem. I mean, we saw it after Hurricane Sandy when people were given forbearances for a few months, and then after 6 months, they said, give me 7 months of payments, we're going to put you in foreclosure. Federal, state, and the city are all working to try to have legislation to try to force the bank's hands. But banks have all different kinds of investor restrictions, and there's, as I mentioned before, there's all types of loans. So what is really important is just to reach out and find out what they are planning and then try to plan for it. But it does boggle the mind that if someone doesn't have money now, that they're not going to have 6 times the money 6 months from now.
And there's different stories out there about different moratorium time limits on foreclosures. What are the rules now about banks not being able to foreclose on mortgages?
So foreclosures cannot happen till August 20th. However, that seems to be being, and there has been a lot of talk about exactly what they are referring to. It does appear that means actual foreclosure sales, the actual, going to the steps and so on. There was also some concern at first about whether co-ops were included, because co-ops technically are not foreclosed, they're personal property. But in the spirit of the moratorium, we have not seen anything coming through. However, the courts are now accepting new court cases. So if someone does get served papers, because there was a while when they were not allowed to start, they are now. So if you do receive papers, you need to reach out to whether it's one of the not-for-profits or an attorney or someone. You can't just put the court papers to the side now and say we will get to them. And for anyone who was served court papers before the emergency was declared, those statutes of limitation as far as how long you have to answer, they're ticking again. So, it's time to pick that up and see what you can do, because you don't want to lose your chance to answer a lawsuit that started pre-COVID.
Right. And I know that the legislature passed a bill last week that applies to mortgages through state banks and mortgage, not banks, but mortgage loan companies. There's another term for that. But we learned that with our bill, there's a very limited number of mortgages that go through state banks. The vast majority go through federal banks where state law doesn't apply. So I say people have to look carefully to see if it's a federal bank or a state bank. But I think in both cases, it's exactly as you described. It doesn't mean they can't start the action now. They just can't actually complete that action if you have not paid. Right?
May I just add something, Rosemary, if you don't mind? With regard to co-ops, as Rosemary said, you don't have to, the lender does not have to start an actual court proceeding. All they have to do is just send notices. And if they send a notice that you're in default and that the co-op, the lender is going to commence not an action, but a foreclosure sale, then it is incumbent upon the tenant shareholder to get into court to seek a stay and to get a determination as to whether the lender is indeed acting appropriately.
And that ties into a variation on a question I'm seeing over here in the Facebook questions. If you are unable to pay and you're a co-op owner, shareholder, and they don't have to go through this normal process, what is the liability that the remaining shareholders face because they have one shareholder who can't pay their mortgage and there may be actions taken upon them or on the building? How does that play out?
Generally, what happens is that if the individual shareholder isn't paying and the effect upon the other shareholders in the building is minimal, because the bank would then, usually if a shareholder is not paying their mortgage, they're also not paying their maintenance. And the lenders, to preserve their interest as being first in line, usually pay the maintenance on behalf of the shareholder and add it to the shareholder's note. So generally, the corporation and the other shareholders are protected. All right, Rosemary?
It depends. It really depends on the lender and whether or not the lender really wants to stay. We have had many situations where even the lenders sometimes feel that it is easier for the co-op to foreclose than it is sometimes for them. So really, and I know it's very frustrating when I keep saying this to people, but it's all so dependent on your one specific situation, your specific lenders, your specific board. There's no one-size-fits-all answer, unfortunately.
So then from the perspective of the person or family in this situation, if I can't pay my mortgage or my maintenance or my assessments, what are my options?
I mean, at this point, if you have a mortgage or a co-op loan, call the lender, try to figure out what their forbearance procedures are. Some lenders are, if you can prove that there's a reason that you are COVID. Some of the lenders want to see that there is a COVID-related reason why you are not paying, and then they may put you on a 3-month or a 6-month forbearance. If you can get something in writing from them, try to do that. Try to get them to send you a letter, an email, something, so the 6 months from now they don't say, "Well, we never said that." As far as for your maintenance and the assessments, talk to the board. You need to talk to the ones who run the co-op and try to work something out. The worst thing to do is just hope that everything will get better and not try to work. At the very least, have a record with both your bank and the co-op that you've been trying, that you've contacted them. Maybe your co-op board agrees to take $100 a month. Maybe something, just you show good faith, and then hopefully the goal is they'll show good faith back.
I think this question is really for me, not the two of you. Will you continue to work on co-op reverse mortgages? Critical for seniors, especially during COVID-19 because of the need for cash. So yes, we did pass a bill last year that would allow for reverse mortgages in co-ops. Of course, only if the co-op board agreed. And it took us a long time to get it through, and we worked with advocates like yourselves, lawyers who knew this field, and we tried to build in all the consumer protections we could, because there were some concerns about how some companies handled reverse mortgages, and we didn't want to fall into some of those dangerous paths. And so we were thrilled that we got that bill passed both houses. And then we're pretty shocked when the governor vetoed the bill because he said there weren't the right consumer protections. And none of us actually understand that. I mean, you shook your head just now, because we really thought we had made sure to cross our T's and dot our I's on consumer protections, and that people do need this. And we're taking another stab at trying to get the governor to explain to us what his concerns are, to make amendments to the bill, so that if we pass it again, he doesn't veto it again. So yes, I am continuing my work on this. Many of us are. I don't know whether you have any other knowledge or suggestions for us.
No, we were very disappointed and very surprised because I actually haven't seen a bill with that many consumer protections built in from the get-go. So we were but I know that I can talk for the not-for-profit advocacy world that we also are going to be pushing for it.
Good. So we're all going to continue to push for it, and for whoever asked about it, please feel free to keep contacting the governor, urging him to take a second look at this bill, because we sincerely don't know what we need to fix, which is a serious problem, because how do you amend a bill when no one will give you the guidance of what they need to have amended? I'm totally open to amending. I just need to know what that needs to be. Okay, jumping into taxes, which we all joked in advance was perhaps not our territory, although I guess it is mine. Taxes on condos have gone up excessively high. Taxes have increased my maintenance by more than 50% of what I pay for common charges. Why is this happening, and why are condos being charged more than private homes in New York City? Will I be forced to move? So let me just say, property taxes are a city tax, not a state tax, and the formula and the assessments and the adjustments to them are made by the city each year, not the state. But I do hear this complaint all the time. And while everybody always thinks they're paying more in taxes than anyone else, technically, a lot of the research shows co-op condo owners are actually paying less in taxes than many other homeowners and renters in the outer boroughs. So we just have to be a little careful what we wish for, because we might all want a different formula for how the city is doing its property taxes. And they have announced a commission, and a report has come out of their commission recommending changes to how they calculate and assess property taxes. But again, in many of the scenarios, Manhattan co-ops and condos would not see a adjustment down. So that's a tough issue. And so I don't know whether either of you want to jump in there, because I'm not sure it's either of your territory. But I
Too
also
hot for me.
Okay. But also there's another related question that popped up on Facebook about, surely the city recognizes that as buildings are being boarded up, commercial spaces empty, that the assessed value of buildings can't possibly be today what it was a year ago or even 6 months ago, and asking whether the city will adjust their assessments based on this current reality. And again, I don't know because it's up to the city, the mayor, and the city council. So I would recommend people reach out to their council members to ask about this, the mayor to ask about this. But there isn't actually a role for the state government in property taxes. So, but I hear enough from people, so I know that these concerns are real. And I just don't know that the city's in a position to do much about it at this point in time. People also ask if there are any senior discounts on taxes as co-op or condo owners. Are either of you familiar with those programs?
No, I'm afraid not. No.
Okay. There is one senior citizen property tax reduction. I forgot the initials of it, but if you're my constituent, if you call my office, we can get you the application for that.
I will say, if you own a condominium, then you
Yes.
can put in for the senior enhanced star, right? Because condominiums are treated the same as houses. So if it's a condo, there are exemptions. I don't know of any about co-ops.
Yeah, I'm not sure either. But I think that my staff are more knowledgeable than me. So again, if you're my constituent, feel free to call my office up and ask that question. I am not the smartest person in my office by a long shot. Okay, a co-op board implements an annual special assessment on a per share basis that approximates the amount of the cooperative tax abatement for all those who are eligible. Doesn't this assessment improperly discriminate in favor of any shareholders who are not eligible for the tax abatement? So I guess there is a cooperative tax abatement, and then the building gets it and I guess applies it across all of the units versus just those who are eligible for the abatement. Is that right?
No. Folks are eligible for the abatement if they can show that the apartment has been their primary residence. That is something that the city requires. And many co-ops will pass a per share assessment equal to that abatement. It's a way in which the co-op can get funds without there being any pain inflicted upon the shareholders. Key, however, is whether it is the tenant shareholder's primary residence. And there has been a case, Appellate Division, First Department back in 2002, in which the sponsor holder of unsold shares made the claim, you're discriminating against me. Everybody else is getting this abatement. Everybody else is not having to pay the special assessment that you issued, but not my primary residence. I don't get the tax abatement. I have to pay. Well, the Appellate Division said, yeah, you're right. You have to pay as long as the corporation met the procedural requirements of passing an assessment. Business judgment rule kicked in. You can't make the complaint that you don't have to pay because your neighbor's not paying because of the special tax abatement. At one time, I had represented a fellow who owned several apartments. It was a building that had small apartments. He owned several of them, and the city basically said, you can't have that many primary residences. So therefore, we're not going to allow the abatement for, I think it was 3 out of the 5 that he owned. He contested it. He was able to get the city Department of Finance to reverse itself because he's able to show, yeah, I am the primary resident of all 5. Wasn't able to get the co-op board to reverse the assessments on the other 3, but going forward, he was entitled to that abatement and therefore didn't have to pay those assessments.
Thank you. I just looked at my watch and I am amazed at how quickly this is moving and how many topics we are not going to get anywhere near. So I guess one more on taxes. SALT. What are the odds that it will be repealed? This is a change in federal law. So for years and years and years, our state and local taxes for properties were deductible from our federal taxes. And it helped quite a bit when you're looking at your total amount of taxes owed, and suddenly the feds change the rules and you don't get a deduction, and you're paying more in taxes. It's absolutely true. Here's the problem. I think it will be very difficult to see the feds reverse on SALT unless they're willing to reverse on the other section of that Donald Trump tax bill. Because what he did was he dropped the tax rate for the wealthiest Americans, creating a large long-term hole in the budget of revenue to be collected, and then he figured he could help balance some of that by ending the SALT exemptions. So in order for the federal government to reverse themselves on SALT, they also have to reverse themselves on some of the tax cuts they gave wealthy people. I think that would be the right thing to do, to undo the cuts to wealthy people, which also would give us the flexibility and room to reverse ourselves on SALT. Again, it's federal, not state, but I'm a little cynical on the likelihood of that happening anytime soon. I get that question all the time. So unfortunately, I don't think anyone can count on that right now.
Throw the rascals out.
Well, that's a perfectly good answer, Kevin. I'm fine with that.
There you go.
I actually think we are out of time for any more questions. I'm just getting to my final notes. A couple of things that I am supposed to make sure I tell everyone at the end of the show. One, I want to thank you both for agreeing to be on here tonight. Appreciate so much your willingness multiple times in the last few years to come and be a resource for the community. And you both do extraordinary work, both as a private attorney with a law firm and as a public service attorney with a not-for-profit organization. So I really can't say enough kudos to both of you for the work you do for my constituents and for the whole city. I also want to remind people that if we went too fast for them, they can watch this on Facebook. If they know other people they think that would find this helpful, they can refer people to my Facebook page or in a couple of days my website to watch it again. And I want to let everybody know that next Thursday, June 11th at 7 p.m., we're going to be having a discussion on the reopening of New York City with Julia Marcus. She's a Harvard Medical School epidemiologist whose recent pieces in The Atlantic have been helping us think about how to have a life during a pandemic. And I think that is a good closing for all of us as we open with recognition that we are all living in complicated times and territory we never thought about probably 2.5 months ago. And now we know from epidemiologists that not only do we have this pandemic, but actually because of climate changes, we could talk about the environment in another hour or 10,000 hours, but that we should expect other changes in patterns of new illnesses that we must confront. So we all need to learn to live with our new normal. We need to hope we get a vaccine as soon as possible. We need to make sure we ensure that everyone is able to get vaccinated as soon as we have a vaccine. Oh yes, and that's my closing reminder. There's new research showing that because of the pandemic, huge numbers of children haven't been vaccinated this year at the ages that they should have. The last thing we want to come out of this pandemic is to suddenly face a new pattern of thousands of children getting childhood diseases that they should not have to have. So please, parents, if you couldn't deal with getting to your pediatrician or your general practice doctor for the last couple of months because you were really afraid to go near doctors because you were protecting yourself and your children from COVID, please, please, please don't forget you want to get back on that schedule for your vaccines as quickly as possible, because we all just need to be super diligent about taking care of ourselves and each other at this time. So again, I'm going to say good night and thank you all for being with us by Facebook or phone. None in person. Someday we'll do things in person again. Thank you so much.
Night.
Thank you, Senator.
Night.